This happened 3 days ago and most Nigerians do not know about it yet. On August 3, 2026, this week, the United States government made permanent a program that could require Nigerian citizens applying for a US B1, B2 visitor or tourist visa to deposit up to $20,000 before their visa is issued. $20,000. Refundable, but only if you leave the United States before your authorized stay expires. Nigeria is on the confirmed list of 50 countries affected. 30 of those 50 countries are African nations. And this is not a temporary pilot anymore, this is now permanent US law. If you are planning to apply for a US visitor visa, if you have family members applying, if you are a business owner who travels to the US, this video is the most important thing you will watch today. Because what I am going to tell you in the next 30 minutes could save you from making extremely costly decisions based on incomplete information. Let us get into it. Welcome back to the channel. My name is Praise and I run Social and Travels, a travel and migration support company that helps people navigate visa applications and international relocation. This video was produced urgently because this development affects a significant number of our viewers directly and I want to make sure you have accurate, complete, honest information as fast as possible. Everything in this video is sourced from the official Federal Register Notice, Reuters, PBS News, Bloomberg Law, and verified Nigerian media sources. Let us walk through everything you need to know. Let me start from the beginning so you understand exactly how we got here and what this change actually means. August 2025, the pilot program launches. In August 2025, the Trump administration launched what it called the Visa Bond Pilot Program, a temporary, 12-month experiment that required certain B1, B2 visa applicants from specific countries to post a refundable financial bond as a condition of receiving their visa. The pilot applied to applicants from a list of countries identified as having elevated visa overstay rates or inadequate screening processes. During the pilot, consular officers could require bonds of $5,000, $10,000, or up to $15,000. The bond was fully refundable if the visa holder left the United States before their authorized stay expired, if they never used the visa before it expired, or if they were denied entry at a U.S. port of entry. If they overstayed, the money was forfeit. The U.S. government said the pilot covered approximately 50 countries. Nigeria was among the countries included from the program's early expansion phases. July 31, 2026, the permanent rule is announced. On Friday, July 31, 2026, the U.S. State Department published a draft Federal Register notice announcing that the pilot program would be made permanent, effective Monday, August 3, 2026. The permanent program makes 3 significant changes from the pilot. First, the $5,000 bond option has been eliminated entirely. The 3 bond levels under the permanent program are $10,000, $15,000, and $20,000. Second, the maximum bond amount has been raised from $15,000 to $20,000. Third, the program is no longer a time-limited pilot. It is now a permanent part of U.S. immigration law under Section 221(g)(3) of the Immigration and Nationality Act. August 3, 2026, the permanent rule takes effect. The final rule was published in the Federal Register and took effect on August 3, 2026. This is current law. It is in effect right now as you watch this video. The pilot's results, why the US made it permanent. The US government's justification for making the program permanent is built on what it describes as extraordinary results during the pilot year. In 2024, before the pilot launched, nearly 45,500 visitors from the 50 affected countries overstayed their US visas. In the pilot's first 10 months, the number of overstays from covered applicants dropped to fewer than 50. That is a reduction of over 99%. U.S. State Department officials called this result proof that the visa bond is an effective tool for enforcing compliance among visa holders. The government estimates that arresting and deporting a visa overstay costs approximately $18,000 per person, making the $20,000 bond also a practical enforcement cost recovery mechanism. However, and this is critical, the pilot also produced a result the government did not predict. The State Department initially expected approximately 2,000 visa applicants would be required to post the bond during the pilot. Instead, roughly 20,000 applicants were covered. And critically, The bond requirement was associated with an 83% decline in visa approvals for affected nations during the pilot period. 83%. That means for every 100 people from affected countries who applied for a US visitor visa during the pilot, 83 fewer were approved compared to before. Immigration advocates argue this is not evidence that the bond worked to reduce overstays. It is evidence that the bond was used as a de facto visa denial tool, making the visa process so financially burdensome that legitimate travelers simply could not participate. Let me now give you the complete list of 50 countries whose nationals may be required to post the visa bond under the permanent program. I am going to read this list completely so that every viewer can confirm whether their nationality is affected. The 50 countries are: Africa, 30 countries: Algeria, Angola, Benin, Botswana, Burundi, Cabo Verde, Central African Republic, Côte d'Ivoire, Djibouti, Ethiopia, Gabon, the Gambia, Guinea, Guinea-Bissau, Lesotho, Malawi, Mauritania, Mauritius, Mozambique, Namibia, Nigeria, São Tomé and Príncipe, Senegal, Seychelles, Tanzania, Togo, Tunisia, Uganda, Zambia, Zimbabwe. Asia and Central Asia, 6 countries: Bangladesh, Bhutan, Cambodia, Kyrgyz Republic, Mongolia, Nepal, Tajikistan, Turkmenistan. Caribbean and Pacific, 8 countries: Antigua and Barbuda, Cuba, Dominica, Fiji, Grenada, Papua New Guinea, Tonga, Tuvalu, Vanuatu. Latin America, 2 countries: Nicaragua, Venezuela. Europe, 1 country, Georgia. Out of the 50 countries on this list, 30 are African nations, making this a program that disproportionately targets the African continent. Immigration advocates and civil rights organizations have raised specific concerns about this geographic concentration. Now let me explain exactly how this bond works in practice, because there is significant confusion circulating about this and I want to give you the precise, accurate picture. Step 1. You apply for your B1, B2 visa normally. The bond requirement does not apply automatically to every applicant from the 50 affected countries. You begin your application the same way you always have, submitting your DS-160 form, paying your MRV application fee, booking your interview appointment, gathering your documents, and attending your interview at the US Embassy or consulate. Step 2. The consular officer makes a determination. During or after your visa interview, the consular officer will determine whether you are required to post a bond. This determination is at the officer's discretion. The consular officer considers factors including your overstay risk profile, your ties to your home country, your financial situation, your travel history, and any other factors relevant to assessing whether you are likely to comply with the terms of your visa. Being from a listed country does not automatically mean you will be required to post a bond. It means you can be required to post one if the officer determines it is warranted. However, given that 20,000 applicants were required to post bonds during the pilot when only 2,000 were expected, the reality is that the bond is being applied far more broadly than the government's own initial projections suggested. Step 3. If required, you complete Form I-352. If the consular officer determines you must post a bond, you will be directed to complete the Department of Homeland Security's Form I-352, the Immigration Bond Form. This is a formal document that outlines the terms of your bond obligation. Critical warning: the State Department has specifically and formally warned applicants not to submit Form I-352 or make any bond payment unless they receive explicit instructions from a consular officer. Do not pay anyone who claims to be collecting visa bond payments on behalf of the US government outside of this official process. There are already fraud operators exploiting this policy to scam applicants. Step 4. You pay the bond through pay.gov. If you are directed to post a bond, payment must be made through the US government's official pay.gov platform. After receiving instructions from the consular officer, you will receive a direct payment link to pay.gov. The bond amount will be either $10,000, $15,000, or $20,000 as determined by your consular officer. Officers are expected to set most bonds at $15,000. The $20,000 level is reserved for cases where the officer believes a higher amount is needed to ensure compliance, and the $10,000 level applies when your specific circumstances justify a lower amount. The bond may be paid by the applicant or by a third party, a relative, friend, or business associate, on the applicant's behalf. Step 5. Your visa is issued with specific conditions. Once the bond is paid, your visa will be issued. However, visa holders subject to the bond program must enter and leave the United States through designated commercial airports or approved pre-clearance locations. You cannot enter or exit through unofficial or smaller entry points. Step 6. Your bond is refunded or forfeited. Your full bond amount will be refunded if you leave the United States before your authorized stay expires, if you never use the visa before it expires, or if you are denied entry at a U.S. port of entry. Your bond will be forfeited, meaning you lose the money, if you overstay your visa, if you violate any terms of your visa, or if you fail to depart through a designated exit point as required. The refund process is administered by the Department of Treasury and State. Timing of refunds after compliant departure has not been specified in detail in the current rule. This is one of the operational aspects that will become clearer as the permanent program runs. Let me now translate this policy into what it actually means for specific groups of Nigerian applicants. Nigerian business travelers. If you regularly travel to the US for business, attending conferences, meetings, trade shows, visiting clients, and you are directed to post a bond, you now face a choice between posting up to $20,000 in a US government account for the duration of each trip or not making the trip. For established businesses with strong financial capacity, the bond is inconvenient but manageable, particularly since it is refunded on compliant return. For small business owners and entrepreneurs with limited capital, having $20,000 tied up in a US government bond account for weeks or months may be genuinely prohibitive. Nigerian tourists and families visiting relatives. For Nigerians visiting family members in the United States, one of the most common reasons for B2 tourist visa applications, the bond requirement creates a significant additional barrier. Family members in the US may be able to post the bond on behalf of the applicant, since third-party payment is permitted. But the financial capacity requirement creates a real access barrier for families without significant liquid assets. Nigerian students applying for tourist or business visas. Students who travel to the US for short-term programs, academic conferences, or short courses on B1, B2 visas rather than student visas may face the bond requirement. This is particularly relevant for students traveling for professional development that does not meet the formal study permit threshold. The 83% approval decline, what it means for you. This is the number that should give every applicant from the listed countries serious pause. During the pilot, visa approvals for affected countries declined by 83%. This suggests that a significant proportion of applicants who were required to post a bond either could not afford to do so or chose not to proceed with their application. The practical effect of the bond is not just financial, it is that many legitimate travelers from affected countries are being effectively excluded from the US visitor visa system because the financial barrier is simply too high. This is the context that makes the bond program so controversial. The US government points to fewer overstays as success. Critics point to fewer legitimate travelers, families, business people, students, as the real and unjust cost of that success. The visa bond program is authorized under Section 221(g)(3) of the Immigration and Nationality Act, a provision that has existed for decades but was never used at this scale until the Trump administration activated it first during his first term and now significantly expanded it in the second. The legal authority for the program is clear and has not been successfully challenged in court. The controversy around the program operates on several levels. The geographic discrimination argument. 30 of the 50 affected countries are African. Critics, including human rights organizations, African diplomatic communities, and immigration advocacy groups, argue that the geographic concentration of the program amounts to systemic discrimination against African travelers specifically. The African Union has raised formal concerns about the program. The argument is that the policy imposes financial barriers on African applicants at a scale that is not proportionate to the actual overstay risk data and that the historical wealth gap between African and Western countries makes the bond uniquely burdensome for African applicants compared to hypothetically similar programs applied to wealthier nations. The legitimate travel suppression argument. The 83% decline in visa approvals is the most powerful piece of evidence for critics of the program. If the goal is specifically to reduce overstays, the bond achieved that. But if the collateral effect is an 83% reduction in legitimate family visits, business travel, and cultural exchange between affected countries and the United States, critics argue this is a disproportionate and unjust outcome that harms innocent people. The government's counterargument. The US government points to the pilot's results as evidence that the program works exactly as intended. Overstays dropped from 45,500 to fewer than 50. The State Department describes this as demonstrating that the bond is an effective tool for enforcing compliance. The government's position is that the financial commitment of a bond creates genuine accountability. People who have $15,000 tied up in a US government account have strong incentive to leave on time. The FIFA World Cup 2026 exemption. The permanent program includes one notable carve-out: athletes, coaches, and support staff competing in the FIFA World Cup 2026, which is being hosted partly in the United States, received a limited waiver from the bond requirement. These travelers must still satisfy every other visa eligibility requirement. The waiver only covers the bond specifically. This exception reflects the diplomatic sensitivity of imposing the bond on international sporting participants during a globally visible event hosted on US soil. Let me now give you specific, practical guidance based on your situation. If you have a US B1, B2 visa application currently in progress, your interview has not yet happened, the bond determination happens at the interview stage. Continue preparing your application as thoroughly as possible. The stronger your ties to Nigeria, the more stable your financial profile, and the cleaner your travel history, the lower your risk of being required to post a bond. That said, prepare yourself mentally and financially for the possibility that you may be directed to post a bond. Know in advance how you would handle that situation, whether you would pay the bond, have a third party pay it, or withdraw your application, so you are not making a panic decision at the consular office. If you are planning to apply for a US B1, B2 visa, you now need to factor the potential bond requirement into your overall decision about applying. Questions to consider. Do you have or can you access $15,000 to $20,000 in liquid funds that could be tied up for the duration of a US trip? Is the purpose of your trip, business meeting, family visit, tourism, important enough to justify this financial commitment? Are there alternative destinations that serve the same purpose without the bond requirement? These are genuinely individual decisions that depend on your specific financial situation and travel purpose. If you have a friend or family member being sponsored to visit the US. If a US-based family member or friend is sponsoring a Nigerian visitor, inviting them, writing invitation letters, planning to host them, they should know that they can legally pay the visa bond on the applicant's behalf. If they have the financial capacity to do so, this removes the barrier for the Nigerian applicant without requiring the applicant themselves to have $20,000 in accessible funds. Protecting yourself from scams. This cannot be overstated. The State Department has specifically warned against unofficial bond payment systems. Do not pay any bond money to any individual or agency claiming to process bond payments on behalf of the US government. Do not use any website other than pay.gov for bond payment. Do not share your bond payment confirmation with anyone other than the consular officer who directed you to post the bond. Visa bond scams are already being reported in the Nigerian media and will proliferate as awareness of the policy grows. On the refund. If you pay the bond and comply fully with your visa terms, leaving the US on time, through a designated airport, your bond will be refunded. Keep every document related to your departure, boarding passes, customs stamps, any departure confirmation. These will serve as evidence of your compliant departure if any question arises about your refund eligibility. I want to close with a brief but important broader context. The $20,000 visa bond is not happening in isolation. It is part of a pattern of US immigration policy changes in 2026 that have specifically and disproportionately affected African and Nigerian applicants. The travel ban that added Nigeria to its partial restriction list in December 2025. The birth tourism crackdown targeting Nigerian applicants specifically. The physician exemption story that revealed how even healthcare professionals from Nigeria were being caught in the immigration freeze. And now the permanent visa bond that affects 30 African countries. This pattern reflects a US administration that has made immigration restriction, and particularly restriction of migration from developing countries, a core policy priority. The tools are different in each case, but the direction is consistent. And for Nigerians who have long seen the US as a primary destination for travel, education, business, and family connection, the cumulative effect of these changes is a US that is genuinely less accessible in 2026 than it was in 2023. This does not mean Americans have stopped valuing Nigerian talent, Nigerian business, or Nigerian families. The physician exemption specifically demonstrated that when the economic need is clear, exceptions get made. But it does mean that the bureaucratic and financial barriers to accessing the United States as a Nigerian traveler have increased substantially, and planning for travel to the US now requires a level of financial preparation and strategic thinking that simply was not necessary 3 years ago. And that is the complete picture. The US $20,000 visa bond is now permanent law as of August 3, 2026. Nigeria is on the list. The bond ranges from $10,000 to $20,000, is refundable for compliant departure, and is determined by your consular officer, not automatically applied to every applicant. The 83% decline in visa approvals during the pilot is the number that tells you the real impact of this policy. What you do with this information is now up to you. Plan accordingly. Prepare financially if you intend to continue applying for US visitor visas. Know your rights and know the official process. And do not let anyone exploit your